Sotomayor at the Second Circuit, Judge Kimba Wood at the SDNY next door. She received her JD from Yale Law School and graduated from Harvard. She's also did some private practice work before joining the Brennan Center at Gibbons PC in Newark, New Jersey. Alicia, turning over to you.
Thank you so much. Welcome, the folks in the room and the folks watching online. It is such an honor to have the opportunity to join you here today and to moderate a panel with this very, very distinguished set of guests. I want to just also thank, particular thanks to the Richard C. Fela LGBTQ Commission and the Franklin H. Williams Judicial Commission and all the co-sponsoring organizations for bringing us all here together today. I'm going to briefly introduce our panel. There are full bios in the program, so I'm going to keep it short so we have the opportunity to hear more from our guests, but encourage you to read the full bios as well. As you've heard and many of you know, Judge Anthony Cannataro is an associate judge on the New York Court of Appeals. He joined the court in 2021 and recently served as well as the acting chief judge. He has served a number of roles within New York's court system over time, serving as law clerk to Judge Siparek, as well as to the Honorable Lottie E. Wilkins. He was elected judge of the Civil Court of the City of New York, served in the Kings County Family Court, Bronx County Civil Court. He was a supervising judge of the New York County Civil Court. He was a justice on of the New York Supreme Court in the First District. He was appointed citywide administrative judge, so he's really seen all of the ins and outs of the New York court system. He was also a founding member of the Richard C. Fela LGBTQ Commission, which he founded in 2016 and served as a co-chair. And he is the second openly gay judge on the New York Court of Appeals. And as we said, we sit in a courtroom today named for the first. Next, I'll turn to Justice Kelly Evans, who serves as an Associate Justice of the California Supreme Court. She just joined the court this year, previously serving as a judge in the Alameda County Superior Court, where she presided over both criminal and civil matters. Prior to her appointment, she served as the Chief Deputy Legal Affairs Secretary in the Office of Governor Newsom. She's also had a number of other roles, including a long career in public service, where she was a Senior Director for the Administration of Justice in the California State Bar, Associate Director of the ACLU of California, Northern California, a Senior Trial Attorney in the Civil Rights Division of the Department of Justice, and an Assistant Public Defender at the Sacramento County Public Defender's Office. And she also currently serves on the California Commission on Access to Justice. Last, but certainly not least, we have Justice Martin Jenkins, who joined the California Supreme Court as an Associate Justice in 2020. And he and Justice Evans are the state's first and second openly gay judges on the California Supreme Court. Justice Jenkins previously served as the Senior Judicial Appointments Advisor to Governor Gavin Newsom, where he advised the governor on the appointment of judges across California. And he also has a long judicial career, but prior to joining the California Supreme Court. He served as an Associate Justice on the California Court of Appeals, and he also previously served as a federal district judge for the Northern District of California, and as a trial judge on the Oakland Municipal and Alameda County Superior Court. He also, prior to his service as a judge, worked as a prosecutor, as a trial attorney for the Department of Justice, Civil Rights Division, and was also an attorney in Pacific Bell's legal department, handling a wide variety of litigation matters. So it is truly an honor to have such a distinguished panel here today, and I'm really excited for the conversation. I'm going to begin by posing some questions, but also wanted to note that there should be cards on everyone's seats. So if you have questions, throughout the panel, please write them on the cards, and we'll leave a little bit of time at the end for the audience to pose questions to our panel as well. So to start us off, I would love to hear from each of you about your journey to the bench. And maybe we can just sort of start along the row. So I'll start with you, Judge Cannataro. You, as I said, have spent most of your career within the court system. You actually, once clerked on the Court of Appeals and now serve there as a judge. How have you seen that institution change? And maybe what was this past year like for you? Just a
That's a
light
two-parter if I
question
ever
to
heard
start us off.
The Court of Appeals is an institution that is definitely steeped in tradition. So there are many aspects of it that haven't changed in the 25 or so years since I clerked there, and Justice Tanisha James clerked there with me, so you feel free to add in. What I think is most strikingly different to me now with the institute, in terms of the institution, are the effects of diversity on the bench, actually. And, we spend a lot of time in the judiciary talking about what the benefits of diversity in the bench are. And one of the things most often cited is that it increases public confidence in the judiciary when they can see themselves reflected in the bench. And that's undeniably true. But there are other benefits, and what I feel as if has slightly changed in the atmosphere of the court is as the Court of Appeals bench has diversified, because it wasn't extremely diverse 25 years ago, there's more of a sense of, I've had occasion to read a number of decisions in preparation for this event, and some of them are 50 years old and some of them are 30 years old, and there's a sense of otherness in the court's decisions. They're compassionate and well-reasoned and intelligent and generally favorable to our community, but there's still a sense of otherness when I read those decisions, that they're talking about a group that they don't know. And now, with the advent of so many different kinds of people on the Court of Appeals, including members of the LGBTQ community over the last 6 years, you don't get that sense of, well, there's our group, and then there are all these other groups who we're going to try to, be as just and fair to as we can. So I feel like the court has become a much more tolerant, a much more empathetic place because of the presence of so many different kinds of people who maybe the members of the court itself didn't have a really deep understanding of previously. So I would say it's improved. As for the last year, that's a completely different issue. It's been a remarkable year for me, and yes, Justice Winslow, probably the most challenging year I've had as a human being. It's challenging in a good way. It was terrific to get my hands in there and try to guide this massive court system through the tail end of the pandemic into what I hope is a new and brighter day for all of us. And it gave me the opportunity to bring my experience as a jurist and my experience as an administrator together and use them in what I think would be the highest expression of those abilities. There were also challenges that were less rewarding. I've lamented publicly, or I did during my time as acting chief judge, about attacks on the independence of the judiciary and a sort of fundamental lack of understanding of the role of the judiciary in our system of government. And I think it's made me much more appreciative of what a good civics education could do for a well-informed public. But overall, the experience has been a positive one, and I know I've grown a lot personally from it.
And how would you describe that role of the judiciary in our system?
I think, in terms of what I said about civics education, I think that sometimes even fairly well-educated people think of the courts as sort of a third policy-focused branch of government. And I think very often people look to the courts to advance whatever their policy goals might happen to be. And there are many who feel, and not without reason, that's not really the function of courts, that they're not supposed to be laboratories for policy change. The core function of courts generally is viewed as setting the ground rules for the resolution of disputes between individuals. And another key function of the courts is sort of to act as a check on the policy-making branches of government. And usually that gets expressed as a sort of anti-majoritarian limitation on what other branches, especially the legislature, can do. So it's been a subject of interest for me to see how people very often will expect courts to advance policy agendas for the good of their communities for completely altruistic reasons, but probably that expectation is probably not justified if you have a really sort of more nuanced understanding of the role of courts in our government.
Thank you. Justice Evans, I'll turn to you now. Could you speak to how your diverse professional experiences and life experiences influence how you approach your current role, and how have you managed to transition from a series of advocacy-oriented roles to serving as a judge?
Be happy to, but first I have to say happy Pride, everyone, and also
Happy Pride.
Happy Pride, and happy Juneteenth as well. And I want to thank all of our co-hosts and our colleagues and co-sponsors of this wonderful event. It's so great to be here. As a very, very young attorney, I was part of a LGBTQ litigation roundtable briefly, and so we periodically met in New York, and so it's great to be back for this panel in this courtroom. It's very meaningful for me. And I'm taking full advantage of New York. I had dinner in Little Italy last night. I had amazing pastries from Chinatown this morning and happened to walk by Magnolia Bakery last night as well. The banana pudding lives up to the hype, so I have to say that. I have been so incredibly privileged to have a very diverse and rewarding legal career. I've done a lot of different things, and a lot of those roles have been advocacy roles. I've had the privilege of both suing the government and also representing the government. Personally, I've been racially profiled, and I've also worked hand in glove with law enforcement on a range of police accountability issues. I've worked in nonprofits, I've worked for the state and the federal government, I've worked in the private sector, I've done a lot of litigation, I've done a lot of policy work. And I think it's really the collection of all of those experiences that allows me to have a very rich and deep understanding, not only of the law, but of people and of communities, and what the law can do. For me, the law is not simply an academic or esoteric exercise. It is about real people. It is about real communities. And I do think state high courts, for better or for worse, whether you like it or not, we are policy-making bodies. We do make policy by interpreting the law. So I think my background, both personally and professionally, enables me to, as I said, have a very rich and deep understanding of a range of issues, and also forces me to be very, very practical, very pragmatic in thinking about the impact of our decisions. I want to make sure, obviously, that they provide clear guidance to our lower courts, but that they make sense and we are aware of the impact on the ground. And certainly, it's the legislature's job to change course if they disagree with decisions that we make, but I feel like those decisions give me just a very rich basis for being a jurist on the state's high court. In terms of advocacy, it's been a while since I've been in a traditional advocacy role. As you mentioned in the intro, I was a senior advisor to both the governor and the attorney general before being appointed to the bench. As a trial court judge, certainly I wasn't an advocate for anything other than what I'm an advocate for now, and that's the Constitution and the rule of law. So there were things in my advocacy career that I may miss, but as I said, I've done a range of work. But let's be honest, it's fantastic to be the person making the decisions.
Wonderful, thank you. It's good to be the judge.
It beats beats the alternative, yeah.
Justice Jenkins, this didn't make it into my bio, but among other things, you were once in the NFL. You have been a federal district court judge, a state appellate judge. You've worked for the governor. Can you say a bit about how all of these roles, how they've been different and how each of them or which of them kind of prepared you for the role that you have now?
I'd be happy to. I too want to echo the sentiments of my fellow panelists. It's such a pleasure and privilege to be here with you this afternoon to engage in this discussion where I know I will learn more than any of them or you will learn from me. In terms of my career and the breadth of my career, I'm sorry to say that my dad, who was a janitor at Coit Tower, maybe some of you have been there when you visited San Francisco for about 35 years, left this earth feeling like his son was a bit of a disappointment. I was told that at his funeral service by one of his friends who said, your dad thought that his second son, Martin, had great promise, but he hasn't been able to keep a job for any long period of time, so he's been a bit of a disappointment. And I say that to say, because I don't think he grew up on a farm in Texas, farming cotton in a little town outside of Houston, and my mother from Louisiana. And I'm saying this because this informs the answer to the question. And they were what I call integrationists, people who came from the Deep South in the 20s and 30s. Their goal for their children were to sort of step through the halls of power, the halls of justice, and corporate America, and to become full-fledged citizens with the right to enjoy all of the fruits of that labor, and that was their goal. So for me, one of the things that I have come to the law with was just a very broad appetite for lots of different work. I started as a young district attorney and very soon figured out that there was one place in the country then in the 1980s, if you wanted to do work that involved the prosecution of those involved in hate crimes, police excessive force cases. This was before any hate crimes legislation existed in any of the states. There was one place to do that work. It was in the criminal section of the Civil Rights Division. There were 17 of us that were dispatched across the country to investigate and try those cases. Thereafter, when I came back to San Francisco, I thought it was probably time to get some civil experience, and I worked for then a regulated public entity, the telephone company there, and it exposed me to civil practice. And I've done the same thing with respect to the bench, starting as a trial judge, where I handled a variety of assignments and was fortunate enough to have my name placed in nomination by President Clinton. And I served on the district court for just shy of 11 years, and then came back to the Court of Appeal in large measure because I felt I was in a fishbowl. There were very few African Americans on the federal district court, and I felt a lot of pressure. We all do to do our very best work, but I felt a lot of pressure that pushed against me living my truth as a gay man. And one would say, and I'm going off a bit here, but I wanted to make sure I get this in. One would say that who has more autonomy than a federal district judge? I think that when you juxtapose that with what I got from my community in terms of being a black man and potentially a gay man, I needed to retire from that position. I came back to the Court of Appeals and I began to do the work, the personal work that has allowed me to be with you here today, living my truth. So all of that to say that I think having had that variety of experience just informs the way that I look at legal issues. There are very few areas, substantive areas of law, procedure I haven't been exposed to, and that serves as a foundation for the way I look at issues and the way I see issues. And I also think that, to be quite honest, having served in all those different courts, and I always call the Superior Court in California the People's Court. They all are the People's Court. There is a rich reservoir of experience and exposure to other people that I think, for me, has created a mindset that I approach this work with great humility always and great empathy always.
Thank you. I want to pick up on a point you made and kind of broaden the question. You sort of spoke about some of the pressures that you faced and experienced when you were on the district court. You know, we're at a moment, it's Happy Pride. This is a time for celebration, but also a time to talk about continued challenges for LGBTQ judges, lawyers, and the broader community. And so wanted to kind of pose that to the group for your reflections on, on Pride Month and kind of the, particularly, I guess, as such path-breaking judges within your courts, kind of the state of LGBTQ representation on your courts and what that means more broadly for the community. Should you go first? Sure.
Well, for me, I think it's simple. At some level, it can be complicated because there are expectations that you can't always meet. They're not consistent with your own personal integrity and how you walk in the world. But I think for many, many years, having been one of a few Black judges on different courts, that I've learned to understand that in many ways my life is not my own. And when I say that, what I mean is that you couldn't have told me how important my presence is as a gay Black man to those communities. And you couldn't have told me how important my experience as a gay Black man, that voice that I have in the discussions that occur on our court. And so I think those two things, when I bring them together and think about them, I understand every day when I wake up that there's a challenge to be met. The challenge is to be my authentic self each and every day. And if I do that, then I bring the best of what I have to offer to my colleagues and the best of what I have to offer to the community that is invested in my success.
Justice Evans, would you like to add?
Sure. Thank you. I have had the privilege of being out my entire professional career. I've also had the privilege of practicing law in large metropolitan areas. So I recognize that my path has been smoother than many, many other LGBTQ people. I also come from a family that has been very loving and accepting. I grew up with my grandmother, and she only had an 8th grade education herself, but she encouraged her 4 daughters and then her grandchildren to get their educations. And even before, I never had an explicit coming out conversation to my grandmother, but there are 2 markers she knew without a doubt. One, she bought me my first pair of combat boots when I was maybe 19 years old. And I'd wear it with my dashiki and my shaved head and all that stuff. I'll show you the pictures later. And 2, there was a time when she was living in North Carolina, and she came out to California, to the Bay Area, to visit me. And my partner, my wife of more than 30 years, we were living together, and we took her out to play bingo one night, and she won the big jackpot. It was like $500. And after thanking Jesus, she insisted that we go to Macy's and insisted that we go to the housewares department so that she could buy us a set of dishes. Now, dishes were the customary gift that my grandmother gave to every married family, every married couple in our family. So there's no doubt my grandmother knew and was fully accepting. Fast forward to being a little bit more direct in terms of your question. All this is to say is I think that those of us who are able to be authentic, to use the words of Justice Jenkins, and open, it's very meaningful, and maybe more so now than at any time in recent history when we have this retrenchment in many areas across the country, places where even saying the words gay are not is not permitted, places where young people are being told. Really, really important that those of us who can be authentic and be role models and speak out and keep doors open. It's so important that we do that. On my very first day at the California Supreme Court in January, I met a court employee, and she came up to me and she said, "Thank you for being an outface, another outface at the court." And so my presence there was meaningful to her. And being in San Francisco, being in the Bay Area, I can sometimes forget how meaningful it still is to have not just welcoming institutions like our institutions, but individuals who are role models, and unapologetically so.
Judge Canatera?
Yeah, I think my experience is somewhere in the middle of those two. Was fortunate, I was fully out by the time I graduated from law school. Maybe I still hadn't had a conversation with my grandmother yet. But so I've experienced my professional life as a gay man, but in a major metropolitan center that was a very easy place to negotiate, comparatively speaking. So I have felt that sense of privilege and watched in sort of a combination of horror and disbelief when in other parts of the country, there's an enormous pressure not to acknowledge that part of who you are, and there's a palpable feeling of, being ostracized or feeling other when you work in places like that. So I've been fortunate in my personal life. I don't know if this is what you meant, Justice Jenkins, but that there is a little bit of a sense as I've moved through my career of sort of having to take on a more symbolic function as a gay man working in the courts as a judge. I remember when I first became supervising judge of the New York County Civil Court, a judge who's in this room, Judge Somberg, called me up and said, the day it happened, the day I got the appointment, "You are the only LGBT person currently in court administration." And I don't know what the purpose of the call was. It was probably just an observation of something. But to me, that sort of added a little more freight to the position. And as I've moved up through the court system, and now, of course, I'm the second gay man on the New York Court of Appeals and succeeded the first upon his very untimely passing, there's even more of that sense of, well, you're kind of a standard bearer for your community, which is a great honor, but it's also an awesome responsibility. So it's been interesting in that regard.
I want to shift us to talk about the courts as legal institutions. So we have some significant anniversaries this year. It's the 50th anniversary of Matter of Kimball, where the High Court effectively ruled that openly gay people can be admitted to the bar, and also allowing Lambda Legal to incorporate in Matter of Thom. It's the 15th anniversary in California of the in-remarriage cases, with Proposition 8 winning shortly thereafter. Would love to hear from each of you reflecting on the role that state courts have played in the arena of LGBTQ rights, and maybe the relationship between state courts and state constitutions and the federal courts and federal constitution. Well, I'm going to shift up the order. How about we start with Justice Evans?
Sure. The three of us, so that we wouldn't be so redundant, decided to split up this answer a little bit. So I think I'm going to talk a little bit about states other than California and New York. And, here we are 50 plus years past Stonewall. But even pre-Stonewall, people, LGBTQ people, were going to not just federal courts, but for state courts for help on a variety of issues, with varied successes. What I want to do on a variety of topics, whether it was protection from discrimination in employment, whether we're talking about relationship recognition, whether we're talking about family issues, marriage equality, all those issues have certainly played out on the federal level, but state courts have played an an indispensable role, sometimes overlooked. What I want to do is just spend a couple minutes using the issue of marriage equality as kind of a case study of what's happened in the state courts. And it's interesting because there have been cases brought all over the country, and I'll focus on maybe, and I'm going to do this very fast. This could obviously be a whole, law school course, but I'm going to do this very fast. And one of the things that's clear is that state courts' success there has not been assured, and it has also not been linear. And that's probably not a surprise to anyone here, but it's the trajectory, and again, using marriage equality as a case study has been interesting. So if Stonewall happened in 1969, the riots in Stonewall, and if we look across the country in the early to mid 70s, there was a series of attempts to gain marriage equality in various state courts across the country. Now, the cases in the early mid 70s pretty much uniformly were unsuccessful, but they're interesting nonetheless, and they were building blocks for what was to come. And let me just zoom through for you. So we had in 1971, we had Baker versus Nelson that went before the Minnesota Supreme Court. There were a couple of law students, two men, Richard John Baker and Michael McConnell, who applied for a marriage license in Minneapolis. They were rejected, and they ended up appealing all the way up to the state high court. The story has it, now I don't know that if this is true, we've got LGBTQ litigation historians in the room who certainly are more expert than I, but the story that I've heard is that the attorneys for the men were not asked a single question during their oral argument. The court ended up saying that restricting marriage licenses to heterosexual couples or opposite-sex couples did not offend the U.S. Constitution, so they lost. They appealed to the U.S. Supreme Court. There were no oral arguments. In a one-sentence decision, the U.S. Supreme Court said that the issue did not raise a substantial federal question. So there you have it, 1971 Minnesota. We zip ahead a couple years to 1973 to Kentucky, and there were two women, Marjorie Jones and Tracy Knight. They applied for a marriage license, and the court denied their request, saying that there was no violation of the state constitution and that whatever it is that they were seeking to do was not a marriage. So it, because whatever union they were attempting to make did not fit traditional notions of marriage, so they were rejected. The following year, 1974, let's move a little bit across the country to Washington State. And there we had John Singer and Paul Barwick. They thought they might have a better shot than the earlier litigants that I mentioned because there was a then fairly new Equal Rights Amendment in the state that prohibited sex discrimination. So they thought maybe this is our chance. The court, however, cited the Kentucky case I mentioned a moment ago and also rejected their request. I'm going to zip ahead a bit. Things got a little bit better as we get into the 1990s. And what was happening, I think there was greater visibility of our community, of our communities. There was visible activism by groups like ACT UP. So things got a little bit better. And we get to 1991, there was litigation in Hawaii, Bear versus Lewin, at least initially titled Bear versus Lewin. And it was a mixed bag, but there was important progress there. So the Hawaii Supreme Court said that under their state constitution, the right to privacy did not include a fundamental right to same-sex marriage. But it also held that the state's Equal Protection Clause did require that in order for the state to discriminate in marriage in the way that it was doing, the state had to meet strict scrutiny. It had to have a compelling reason, and it had to have a narrowly tailored pathway for its policy. So the Hawaii Supreme Court ended up remanding. There were lots of contortions in the legislature. It took a few years for the case to go to trial. The trial court found for the plaintiffs, and found that the state had not met its burden and ordered that same-sex couples in Hawaii be allowed to have marriage licenses. But the court ended up putting a stay in place so that the case could be appealed to the Hawaii Supreme Court. And in the interim, there was an initiative on the ballot. The voters ended up amending the Hawaii Constitution to bake in discrimination. So there was an important doctrinal victory, but the voters took it away. Nonetheless, I think we learned a lot about the potential pathway there. Let's zip ahead to 1999. We'll go back across the water in the country to Vermont, where the Vermont Supreme Court said that the state's marriage laws were discriminatory. They said they were discriminatory. They said, but legislature, it's up to you to deal with the discrimination. And the legislature ended up doing what a lot of state legislatures did in the 90s and throughout the mid-2000s, and they implemented a civil union policy. So a marriage light, marriage by another name, marriage light, we'll say that. We have to move into the 2000s to get to the first successful marriage cases in the state. Excuse me, my little contact lens issue. And we go to Massachusetts in 2003, the year my daughter was born, in the Goodrich case. So the Massachusetts Supreme Court was the very first state Supreme Court to say that there was a right to marry. There were seven couples that brought the case, and they won under the Massachusetts Constitution and the Massachusetts laws. And there were, as in Hawaii, there were efforts to change the state constitution to take that away, but they were unsuccessful. So the first couples were legally married in Massachusetts in 2004. Move ahead a couple years, and I'm not going to talk about the California cases, the in-ray marriage cases in California, but just to preempt a little bit, California also said that excluding gay and lesbian couples from our state's marriage laws was unconstitutional under our state constitution. And so California became number 2, but it was kind of a Pyrrhic victory. Marriage in California was legal for 5 months because there was through direct democracy, there was another ballot initiative, Prop 8, Proposition 8 is what we called it, that went on the ballot, and it amended the California Constitution to prohibit same-sex marriage. So for 5 months, marriage was legal for same-sex couples in California. My partner and I got married during that 5 months. Marriage then became illegal, but it was a very odd period. The folks that got married during those 5 months, our marriages were legal in California. There was a question about whether the full faith and credit clause of the U.S. Constitution would require any other state to recognize the marriage. But for a number of years, no one else was able to get married in California, no other LGBTQ couples. A couple other state cases worth mentioning. 2008, we zoomed to Connecticut. The Connecticut Supreme Court held that allowing same-sex couples to not form same-sex unions violated the state constitution. And then we go 2009 to Iowa. Same thing, Iowa Supreme Court made history with the first unanimous state court decision saying that it was unconstitutional under a state constitution to have marriage inequality. And they also were the first state in the Midwest to find for marriage equality. So the marriage cases are just one example of the laboratory that state courts have been for LGBTQ folks. There's a concerted effort by a number of attorneys and advocacy organizations now to turn back to state courts for relief, as we see the federal courts being unwilling in this moment, or less willing at times, to protect or expand rights, including LGBTQ rights. So the next chapter in state courts is being written as we speak.
Thank you. Justice Jenkins, would you like to go next?
Yeah, I think that the outline that Justice Evans has given you and sort of the waxing and waning that she talked about across the country, certainly you can overlay quite nicely over what's transpired in California. But I want to start this, and I'll keep it at a sort of very high level so we can get through. I think we have to start in terms of California, and state courts and Supreme Courts have always been incubators, I think, for change, always out ahead for the most part, the United States Supreme Court to be sure, and federal courts as well. In California, there was a decision that became very important in the marriage case for marriage equality, which is Perez versus Sharp. Back in 1948, striking down a miscegenation statute for a Mexican gentleman who wanted to marry his white wife. And the Supreme Court in California said in 1948 that the failure to allow those marriages to go forth, interracial marriages, violate a fundamental liberty interest in the California Constitution. And it talked expansively about what comprises that liberty interest, that the private decision to decide to marry, the economic interests that marriage supports going forward. It actually lays out the analysis that the California Supreme Court utilized in the marriage cases some 60 years later. And of course, it was ahead of Loving versus Virginia, when the United States Supreme Court actually caught up and decided that interracial marriage could not be deprived, otherwise was constitutional. California then, after Perez versus Sharp, the next time we see any litigation in the Supreme Court involved a case called Gay Law Students versus Pacific Telephone and Telegraph. And in that case, the telephone company there in California, which ultimately became my employer, had denied the right of employment specifically to gays and lesbians. And being a regulated public entity, the trial court found that the telephone company could do such, that in fact didn't look to Perez, found that in fact there was no constitutional predicate for that protected discrimination against gays and lesbians. California Supreme Court entered the fray and decided that in fact that was incorrect, and again went to Article 1, Section 7, and an interesting analysis because the court doesn't speak in terms of orientation at all. It speaks at a very high level about the fundamental interests that are impacted in the denial of employment in that setting, and the California Constitution prescribed that. There was another claim in that case premised on what is our equivalent to Title VII, our FEHA statute, and the plaintiffs pressed a claim under that statute, and the Supreme Court basically said, in no uncertain terms, that's not a protected classification, and so denied that claim. Several years later, then, the legislature got involved after a Court of Appeal decision under the Public Accommodations Statute in California, the Unruh Act. It's equivalent to 42 U.S.C. 2000, subsection A. And the Intermediate Appellate Court determined that sexual orientation was a protected classification, even though there was no specific reference in the statute to it. The legislature caught up several years later and codified that holding, the Rulon holding, which is Rulon versus Kowalski, and codified that holding, enshrining sexual orientation as a protected classification. We come to 1999, there's no court, at least not the Supreme Court, any involvement on any of the issues, the panoply of issues that involve protection for gays, lesbians, and other members of our community. But in 1999, the California legislature amended the Fair Housing and Employment statute and added not only sexual orientation, but then in 2011 added protection for gender ID, gender expression, as well as sexual orientation. So that sets the backdrop, these statutory amendments, and over time, and as my colleague said, the 1990s was a particularly, late 1990s, early 2000s, a fruitful time for protections coming online. We come then to the marriage equality case in California. Interesting case because it came on the heels of then Mayor Newsom, who is now our governor, who ordered the clerk of the court in the city and county of San Francisco to begin issuing marriage licenses to gay and lesbian couples. And the writ was filed to preclude the clerk from doing so, and that case then came to the California Supreme Court, the Lockyer case, where the Supreme Court basically said that the decision by the clerk, i.e. by the governor, was ultra virus. The clerk could not make the constitutional decision as to whether or not the statute in California was prescribed same-sex marriage was unconstitutional. So it ordered that the marriages end. And I'll just add a little aside. I happened to be a federal judge when that ruling came down. I also happened to be a federal judge when Governor Newsom, then Mayor Newsom, ordered that same-sex couples could be married. And I went to work, as I did most Saturdays. My chambers was on the 19th floor. Got there about 9 o'clock on a Saturday morning. It was pouring rain. And looked outside my window, and I just will never forget what I saw. There were men and women lined up around City Hall and extending down Van Ness Avenue, which is about 5 city blocks to Market Street, in the pouring rain, waiting to get married. And it just brought home to me that this, simply put, this is really about people who have found love and want to have their relationship, that love, treated as equal. In that sense, domestic partnership doesn't provide the same sorts of, I think, considerations and recognition that full-fledged marriage does. So the marriage cases come online, and the Supreme Court for the first time says that a statute that had been passed maybe a year or two before, Proposition 21, which defined marriage as between a man and woman, was unconstitutional under the California Constitution. Again, looking to Article 1, Section 7. And it also then seized on the amazing language from Perez versus Sharp to solidify the constitutional underpinning of that determination. And then it did something else. It also found that statute, which passed by 61% of the California voters, also violated the equal protection provision in the California Constitution. And it does an eloquent job of talking about the stigma that's associated. That is sort of the hallmark of equal protection analysis in arriving at the decision. And then last, the court also struck the statutory language defining marriage as between a man and a woman as congruent with and consistent with the decision that it had already made. Before the ink was dry on the California court's decision, as my colleague has already indicated, those who were upset with the Supreme Court's decision managed to qualify a proposition through their initiative process, which is constitutionally ordained, Proposition 8, which then redefined marriage as only between a man and a woman. And the Supreme Court now, having already sanctioned the validity of same-sex marriage, now is in a position of trying to decide, and the issue before the court was whether that was a proper amendment or a revision. A revision of the Constitution meaning a wholesale change in the underpinnings, the foundational precepts of the California Constitution. It found that it was an amendment, and therefore, Proposition 8 changed the definition of marriage, which then led to a lawsuit in federal court, Perry versus Hollingsworth, where there was a challenge to Proposition 8 on 14th Amendment, equal protection grounds. And as you probably know, that case bounced up and down from the California court to the Ninth Circuit, back down to the Ninth Circuit. And essentially, the end result was that the Ninth Circuit's decision became the law of the land because the Supreme Court found in the filing before them that the plaintiffs didn't have standing to raise the issue. It never reached the merits. So where we are in California in terms of marriage equality is we have a decision out of the federal district court, and of course we have a Obergefell. But if Obergefell should fall, then California has a decision out of the Ninth Circuit that didn't embrace fundamental marriage equality. It decided that the proposition was unlawful because it withdrew a finding of the California Supreme Court that was constitutional. It was not an embracing decision for marriage equality. That language still remains a part of the Constitution. California is dormant, but it could be revived, and there could be further litigation. And I just did a hit before I came to see how many bills there were in the last several years in the California legislature that involve issues related to gays, lesbians, transgenders, gender expression, and there were over 600 bills in the last 2 years, and they range from issues involving elder care to education to hate crimes to fairness, government contracting. And one interesting one, and I'll end with this because I've probably gone on too long, there is a bill currently now to amend the family code to require trial judges to determine or factor in whether or not a custodial parent, a parent who wants custody, is affirming of a child's asserted gender ID. We'll see where that goes.
Judge Canatera.
I think I probably have the easiest job here. I don't have to recount for this audience New York's history with LGBTQ rights in the courts, and I consider myself woefully unqualified to do so in this particular group. But let me just first give credit where credit is due. In New York, I think a lot of our most notable progress in this area has come to us through legislative bodies, through the New York State Legislature, the New York City Council, and even sometimes by executive order. The courts have clearly been part of the dialogue, and I think it's fair to say that our progress hasn't been linear either, or maybe it has been linear in the sense that progress is always in one direction, but the pace of change hasn't, it's been sporadic. You know, I'm happy to say that the courts have not stepped in to take rights away once given, but our history of you know, finding rights in the courts is not uniformly positive, and I guess the New York marriage equality case sort of stands out for me as an example of that. But, you know, the courts have had a role to play, and it was suggested to me that I look at cases from the Court of Appeals that are celebrating their 50th anniversary this year, two specifically, matter of Kimball, which recognized the rights of gays and lesbians to join the bar, and matter of Tom, which allowed for the incorporation of the Lambda organization, which, as everyone knows, is an LGBTQ advocacy group. And both those cases sort of stand out to me as examples of that otherness I was talking about before, especially Kimball. It's a relatively short decision. It might be a memorandum decision, actually. But it implicitly recognizes that there might have been some, especially those who were involved in the admission of attorneys to the bar, who found gays or lesbians and their lifestyle to be distasteful, if not offensive, but the court felt that letting them have admission to the bar was nonetheless the greater good. But you certainly don't feel the warm embrace of the courts, of the Court of Appeals anyway, in a decision like that. And in Ray Tom, which allowed for the incorporation of Lambda, not quite, you know, it's not quite as openly out there, but the court didn't fully embrace the creation of an LGBTQ advocacy organization. It just sort of said, well, what they're doing isn't so horrific that they shouldn't be incorporated. I think you have to wait another 15 years or so to really sort of get that warmer embrace from the Court of Appeals with Braschi v. Stahl, which I think was just about 15 years later, or maybe 16 years later, which redefined family for purposes of rent regulation in New York, and in the process did it with a gay couple, and in the process really sort of for the first time, I think, granted members of the LGBTQ community full, unwatered down recognition and rights as members of the community with all the rights and privileges and responsibilities that go along with it. And I actually noticed the other day when I was looking at this, Wikipedia, which I'm sure is entirely authoritative on this subject, said that the decision represents the first time a court in the United States granted any kind of legal recognition to a same-sex couple. So assuming that's true, because I didn't fact check that, but assuming that's true, that would certainly mark a high watermark. And there have been other decisions that have come from our court, Brooke SB, which sort of, again, recognize, sort of redefined what it means to be a parent for purposes of custody and visitation, but did it through a lesbian couple. And the court, I guess, in the New York Court of Appeals hasn't shied away from taking on these issues and imparting a sense of fundamental fairness to these questions when the opportunity presents itself. But there certainly have been occasions where they've sort of held back and said, we think that this is a legislative prerogative. It's, I guess, what you would call a very incrementalist approach to rights through our courts in New York. But as I said, the legislature has really been on the cutting edge of this, happily so, for many years.
We have about a little more than 15 minutes to go, so I wanted to invite audience questions. If you can write on the cards if you have any questions, and we can work them into the conversation. I will pose a question while people write, so we can kind of a brief question at least. We're also the point you just raised about the feeling of otherness in reading some of these opinions was just so striking to me. And while I would say both the courts in California and New York have made remarkable progress in reflecting kind of the diversity of the communities that are impacted by the decisions coming out of the courts, nationally, there are many state courts that are really lagging behind in some places quite dramatically. So for example, the Brennan Center collects data on state Supreme Court diversity. In 18 states, there are no justices at all on state high courts that identify as people of color, including in 12 states where people of color make up at least 20% of the population. Recently, Lambda Legal did a study a few years ago looking at LGBTQ representation on courts, which again is, there's a stark underrepresentation. So would love to hear any brief thoughts that anyone on the panel has about, some of the hurdles to building a more diverse bench and maybe lessons from your own experiences. Each of you in many ways have been path breakers about, what steps we all should be taking to build a more diverse bench. If anybody wants to jump in.
I'll start because I served as Governor Newsom's Judicial Appointment Secretary, which meant that I was responsible for making recommendations to fill all of the vacancies that occur across California. And one of the things that I learned during my time as a judge, but I was more pronounced as I would go around the state. I got shut down by COVID-19, but there are 58 counties in California. I think I had visited 25 of the superior courts across the state, talking to bar associations, talking to the bench there, with the mindset of making sure that people understood that the inn was open for all who wanted to apply. That wasn't true when I became a judge in 1990. I shouldn't say not true, but there was certainly a feeling because no gay and lesbians were being appointed to the bench, very few African Americans, very few Latinos. And this, in my view, is a pipeline issue as well. You have to have people to appoint, to consider. And so one of the things that we did in California was not just me going around, and now Louis Cespedes, who's taken over that job, doing an extraordinary great job with it. But talking to groups, targeting specific groups, and saying, you are welcome. We desire to have applications from you. And then spending time, we've developed a mentor program where sitting judges, and I'm just proud to say this, there are about 300 or 400 judges in California, both in the appellate courts and in the trial courts, who are matched with individuals who are thinking about the bench and talking to them and sort of pulling back the curtain so that they understand what the job is about, and they also understand why their skills are a good match for it. And I think through that process, that has started before I became appointment secretary. I mean, the California Supreme Court is probably the most diverse Supreme Court in the country. Our Chief Justice is a Latino woman. We have an African-American woman, Leandra Kruger, and my good colleague here, Kelly Evans. Goodwin Liu is an outstanding scholar, and member of the Asian community. And so it's been a majority women court for the last 12, 15 years. And so I think all of that, you have to be intentional about it. There's nothing discriminatory about that. And you have to communicate a message to people that where some minority groups opt out, they should opt in, because their applications will be received and vetted in a way that is fair and objective.
Anyone else like to jump in? Judge Canatera?
I'll just say this is a discussion we had as recently as last month at the Court of Appeals. Not so much diversity on the bench, but diversity with respect to the people who appear in front of the Court of Appeals. But it is true that there's a pipeline aspect to this. The most recent addition to the New York Court of Appeals was someone who appeared in front of the Court of Appeals quite frequently, especially when she was Solicitor General of New York. So I do think that increasing diversity in the bar should, to a certain extent, ameliorate whatever problems exist with respect to diversity on the bench. And I also think that starts right at the ground level. I know for my chamber's hiring, diversity is maybe the number one factor. I sort of thought when I came on the Court of Appeals that I would just have a completely, I'd have, pick of the litter, basically, with respect to every young lawyer in New York. And it's been a little disappointing to see that while I get some very highly qualified, well-credentialed candidates to come work for me as law clerks, the amount of diversity in the applicant pool that comes to me is pretty sad, I have to say, to the point where I didn't think I'd ever have to do this, but I go out and I ask people to, send good, diverse candidates my way. So there is certainly a lot of work that has been done, and we, the Court of Appeals as a group, have decided to sort of come out publicly a little more and encourage members of the bar, prospective attorneys, young new attorneys to consider careers in the courts, to consider careers on the bench, for the purpose of trying to do better than what we've done so far.
I think my two colleagues, I agree with everything that they've said. The only other thing I would add, people do self-select out for a variety of reasons, so that's why the mentorship is so important, the outreach that you're talking about. And one of the reasons I think that candidates often self-select out of these jobs is them feeling that they're not worthy, what some people call imposter syndrome, so that the more that we can demystify the process, give the peek behind the curtain, and encourage people to opt in by this sort of outreach. We at the California Supreme Court, we actually try to back up our outreach even. We do some community sessions in the community where we invite high school students to come and observe oral argument and do Q&A session with the justices. We did one just a few weeks ago in San Diego, and one of the last things and it was a very, very diverse student population. We had about 100 young people in the audience. And one of the last things I said to them is, we'll keep these seats warm for you. Because I want them to start thinking of themselves in these roles.
So we got a number of excellent questions from the audience. I'm going to group them, so I'll ask 2 questions together and then another 2 questions together, and we'll invite anyone on the panel that wants to answer any component of them to please jump in. So the first set of questions, so I'll pose them in turn. First, do you feel that the current assault on transgender people, including minors, is analogous to the opposition to marriage equality? And sort of reflections on jurisprudence that exists to protect transgender children. And then a second question is, how each of you referenced the responsibility of visibility and representation as diverse judges, since that representation includes lived experiences that are different than your own, such as bisexual people and transgender people and non-binary people. How do you navigate those differences and continue to build your own diversity awareness? So I'll pose for anyone that would like to answer one or both or a component of those questions. Anybody would like to jump in?
I'll just say real briefly, more I guess with respect to the first question, but the second as well. The experience of the transgender community, especially the recent experience of the transgender community, has been such a huge disappointment to me. And perhaps it's naive to think that once you fight these battles for other communities, for acceptance and inclusion, that sort of paves the way for more acceptance and more inclusion of arguably different communities, but then we could have a very philosophical discussion about what does it really mean to be different or other. But it's been it is a continual source of amazement to me, in a very negative way, that this fight just has to start basically all over again, and the level of animus that's been put out there for the trans community, especially recently, has been, in my experience, because I grew up sort of in a post-Stonewall reality, has been unlike anything I've ever seen before. It's hard. It's really hard to watch. I'll say that.
I think there are a lot of analogs, but I also think there are differences. One thing that is the same is that the tired playbook to find a vulnerable group or community to scapegoat for other political purposes, that's very much the same, and it is incredibly disappointing and demoralizing and dangerous. That's what's most concerning to me, is that it's dangerous. People's lives are on the line. Children's lives are on the line. But it's so closely tied to, it's just part of it, like I said, a tired playbook of scapegoating that's used for other political purposes. In terms of the question of how we all know best our own experience, and we don't walk in other people's shoes or have their experiences. I think part of it is approaching the law from what Justice Jenkins so eloquently described earlier. It's from a place of humility and recognizing that first and foremost, and trying to always question, at least myself, what my biases, what my implicit biases are, and to always try to learn more directly from impacted communities that I'm not a member of. And so I do very broad outreach in terms of my hiring and my staff to have it be as diverse as possible. And then I also meet with as many different community groups and bar organizations and individuals as I can of various communities as well.
I can't add much more to what I think are real solid answers given by the members of this panel. I will say that some of what's happening with the transgender community, and at least in California, leveraging all of this fear and hurt around, for instance, drag queens being predators of some type, in many ways reminds me of some of the tropes that I heard as a young kid, where black men were, described for their strength and sexual prowess, and that they were a danger to white women, and that was a justification through fear to keep those communities apart. So I think we have been here before, and there are analogies, but I also think it's, in my experience, and I'm older than everybody on this panel, but in my experience, there are always inflection points, and we are in one now, I think. And what that allows individuals to do, people of goodwill, is to think about these issues long and hard, to become re-energized about them and strategic about them. And that's how we change society, is through that process. So rather than, I'm very concerned about what's transpiring, but I also know that there's a window through, that we know that if people stay the course and get re-energized, there's a way through. And I will just say, to the other question, I tell lawyers all the time, your job is to learn law, but more importantly, to learn about people. People who don't come from where you come from, but who may be sitting on those juries. And when you're questioning those people, having a sense about who they are. We can't walk in each other's shoes. I've had a different life experience than Judge Canatero or even Judge Evans, but that doesn't excuse the obligation for reaching out and learning about people. So when we set up the governor's vetting process in California for picking judges, I spent a lot of time reaching out to the transgender community, gay and lesbian community, to make sure those voices were in that room. That sometimes what comes through as code for why somebody is not qualified gets called out for what it is.
Thank you. I wish we had time for the remaining questions, but I see that we're right towards the end. I might just invite if there's any final words that anyone would like to add to the conversation.
I'll just say thank you again for this discussion, and thank you all for taking time out of your days to attend. I assume we'll probably be around for a few minutes, so I look forward to meeting as many of you as want to come up before you run back to your day jobs. Thank you again.
Thank you.
You said day jobs, right? Yeah. Yeah, I just wanted to say thank you as well. It's been an honor, especially to appear here with these two esteemed transcontinental justices, and happy Pride, everyone.
I'd just like to share with you a poem that I sometimes call on, particularly in times that seem dark and challenging. And I found this when I was trying a police excessive force case in the Deep South, having a bad day, and I called a friend for some support. And he told me to read this poem. It was written by Langston Hughes, one of the Harlem Renaissance writers, along with Zora Neale Hurston and others. And it's called Dream of Freedom. And I just think it's so appropriate for what's happening now. And it reads as follows. There is a dream in the land with its back against the wall. By muddled names and strange, sometimes the dream is called. There are those who claim this dream for theirs alone, a sin for which we know they must atone. For unless shared in common like sunlight and like air, the dream will die for lack of substance anywhere. The dream knows no frontier or tongue. The dream knows no class or race. The dream cannot be kept secure in any one locked place. This dream today, embattled with his back against the wall, to save the dream for one, it must be saved for all. And I think that's, for me, my North Star in all that I do.
That is a beautiful way to conclude this discussion. Thank you again for joining us here today.
Amazing as always.